Welcome to the campus of North Idaho College and today's broadcast of the North Idaho College Public Forum. The crew is comprised of North Idaho College television students. Your moderator is North Idaho College political scientist Tony Stewart.
Today we bring you the second part of our two-week series from Eastern Washington University's political science faculty, in fact from the School of Public Affairs. We're very fortunate to have with us today, first of all, Dr. Joseph Schuster, who's from that department as I've indicated, and also Dr. Neil Zimmerman, who serves as Dean of the School of Public Affairs. We're going to discuss today the topic, the legal process. We're going to give emphasis to the Fourth Amendment and the question of the exclusionary rule. Gentlemen, it's a pleasure to have you here, and as always, I'm so excited when we can have people from your institution because the programs are always of high quality. May I start out with you, Dr. Schuster? We'll talk about the Fourth Amendment for our viewers who have not had the privilege of having classes in the field. Would you give us just a little bit of historical background of the Fourth Amendment section dealing with search and seizures and how we evolved through the process to adopt the exclusionary rule?
Well, the Fourth Amendment itself was adopted as a reaction to general searches in England and to what was essentially the same thing and was known as the writs of assistance in the United States. The amendment itself, which states, of course, that unreasonable searches and seizures shall not occur, the amendment itself does not contain an exclusionary rule. The exclusionary rule was first adopted in 1914 in Weeks versus United States as applied to the federal jurisdiction and was applied to the states in 1962 in Mapp versus Ohio. And it states that evidence which is obtained in violation of the Fourth Amendment may not be used in court. And that's the exclusionary rule that we're talking about.
Dr. Zimmerman, as we deal with exclusionary rule, that takes on many complexities, I know, and as has just been indicated in the discussion, there's different kinds of evidence that may be obtained in a number of different ways that may be legal or illegal as it relates to the interpretation of the court. In other words, the point I'm asking you to address is there are a lot of different ways of, in individual cases, talking about evidence that's illegal. It's not just from one source, such as searches in homes.
No, it could be any kind of evidence that the state or the police, depending upon who you choose to focus upon, gather in a fashion which is contrary to the Constitution. Basically, the presumption is that the police may not violate a person's privacy, absent what the court has called probable cause. That is, some reasonably based belief that there's evidence to be found in a particular place, a particular evidence, and based upon either exigent circumstances, some sort of emergency, or on a court order, a search warrant, the police may then go and gather that evidence. If they do that, if they go and gather the evidence without having probable cause, then you have something which has been illegally seized. And the court has said that may not be put into evidence in a court of law. The difficulty arises most often in the context of possessory offenses, drugs, illegal weapons, those kinds of things. But it could arise in any kind of case. And of course, you get some very serious cases, very dramatic cases, where the evidence might be thrown out, and you might either make the conviction much more difficult or have a prosecution simply thrown out. If you don't have the evidence, say in a drug case, if you can't submit the drugs, you don't have a case. In different kinds of cases where you're dealing with something that's not so central to the matter, the prosecution may go on. You simply wouldn't use that piece of evidence that the police gathered illegally.
So it depends a lot on how much evidence you have. In some cases where evidence is thrown out, it's so key to the case, without that you would not be successful. I assume that other cases where it would not make the difference in pursuing the case.
Correct. There may be, as I indicated, some kinds of cases intrinsically involve a piece of evidence that you have to have. The typical drug case requires that you be able to admit the drugs. If you can't admit the drugs, there's no crime. In a, say, a burglary case or a robbery case or a murder case, there may be all kinds of other evidence, confessions, other sorts of physical evidence, and the trial could go on. In fact, in terms of the data gathered, we aren't talking about large percentages of cases being thrown out based on the exclusionary rule. The data that the court dealt with, both the dissenters and the majority in the recent case dealing with the exclusionary rule, they were talking about percentages of cases generally less than 1%. So it's not that big percentages are being thrown out, but that it's a series of cases, and people who are probably guilty are not being convicted.
But those cases get such publicity that
They do.
the general impression of the public, I think, is that through the exclusionary rule that an awful lot of individuals are released that would otherwise be tried. But I'm glad you brought that statistic out.
Well, I think it's important to note with respect to this that the Fourth Amendment of the exclusionary rule, at least, operates to exclude evidence which otherwise, with respect to which there's no doubt as to its validity. If you search my home without a warrant, or with a warrant that does not conform to the requirements of probable cause, and you find in my house contraband, marijuana or something like that, the fact that you have violated the Constitution doesn't change at all the fact that I possess the marijuana in my home. So Benjamin Cardozo, who was later Chief Justice or Justice of the Supreme Court, and when he made the statement, he was on the Court of Appeals of New York, stated in People v. DeFore that the problem with the exclusionary rule was that the criminal goes free because the constable blunders. And there are many people, including a number of people in the present court, who feel that we pay a very, very high price in terms of allowing, as Neil said, not only probably, but in some cases certainly, except in the legal sense of having been adjudicated guilty, certainly guilty people go free. And,
I'm going to get into some questions with you about specific examples of evidence that would be legal or illegal. Mm-hmm. Viewers will like that. I'm sure that's very specific. But before we do that, I would like to get both of your opinions concerning the Fourth Amendment, and of course through incorporation of the 14th makes this applicable to both the states as well as the national government. In the Constitution, it says that one has protection from unreasonable search and seizure. So I guess I have a two-part question. One, certainly the Constitution does not forbid law enforcement from making searches of certain types if they're reasonable. I'd like for you to respond to that. And secondly, what is your personal position on the disagreement between the liberals and conservatives on the court about whether we should have the exclusionary rule or how extensive it should be?
Well, maybe I could jump in there. I am a proponent of the exclusionary rule, and I think part of the problem is the kind of position that Dr. Schuster has attributed to Justice Cardozo. And I think what we have is really a basic misconception of what's going on. That is, the criminal doesn't go free because the constable blundered. The criminal goes free because the evidence was illegally seized. Now, the evidence is illegally seized because it was seized in violation of the Constitution. If the Constitution hadn't been violated, the evidence wouldn't be there to be submitted in the first place. So I would argue with the basic proposition it's a problem with constables blundering. It's a problem fundamentally with a restriction upon governmental activity, a restriction which obviously applies to the police, but which I would argue, and I think the exclusionary rule is an attempt to effectuate this, applies to the state as a whole, and the courts are part of the state. If the constable, the police may not search illegally, how can then the state, through the court, through the judge, carry on this illegal seizure through the admission of the evidence into court? So I would argue that absent any argument about deterrence, whether it stops illegal searches and seizures or not, the exclusionary rule is an inherent part of the Fourth Amendment, of the whole idea that there are some things which government may not do. and that prohibition extends to the government as a whole, not simply to the police. That is not the position the court currently takes. That is the position some of the dissenters on the court take. But I think it makes much more sense in terms of a prohibition on government to consider the government as a whole, as opposed to simply focusing on the police.
Dr. Schuster, how do you feel about the exclusionary rule?
Well, I wouldn't quarrel, and the court has not quarreled, with the exclusionary rule as being necessary, at least to some extent. Ultimately, the validity or the lack of validity of the exclusionary rule, as Chief Justice Berger recognized in the Bivens case, and has been recognized by White, I think it was, in Leon, in United States versus Leon. Ultimately, the validity of the exclusionary rule depends on the degree to which it does or does not deter police activity, and the degree to which there are other options available to deter violations of the Fourth Amendment. Certainly, I wouldn't take the position that we should leave the Fourth Amendment without any kind of thing to make sure that it is enforced. But it can be argued, two things can be argued. One, that there are other options available to deter violations of the Fourth Amendment. And secondly, that at least for the private citizen, or at least for the citizen who is in fact not guilty of any crime, the exclusionary rule, the application of the exclusionary rule does nothing at all to assist that particular individual. For example, again, if my house is searched by the police in violation of the Fourth Amendment, and nothing is found, the exclusionary rule does me no good at all. You see, it does me no good because there's nothing to exclude. Therefore, if the only deterrent there is to police activity is the exclusionary rule, then I'm left without any kind of recompense at all, except the civil suit, which is always available to anybody, the person who's in whose house illegal stuff has been found or otherwise. So I think what is proper is what the court does right now. Basically, what the court has said in United States versus Leon, or where I think they're going in United States versus Leon, and probably where they will go in later cases, is that as long as the police officer is acting in good faith, as long as there is not a deliberate violation of the Fourth Amendment. And I think it's important to understand, and I'm sure Neil will agree on this point at least, that violations of the Fourth Amendment by the police are quite often, perhaps more often than not deliberate. I spend half a quarter teaching what the subtleties of what is a violation of the Fourth Amendment to students, and I could spend a whole quarter or 2 quarters doing it. Now, how can you expect a policeman who must act very, very quickly to how can you expect him to go through all the Supreme Court rules and apply them to a particular case? If he does this and errs, you can't say that he has deliberately violated the Fourth Amendment. So what the court has done in the Leon case is to say, if the police officer has gotten a warrant and is acting in good faith on the belief that that warrant is valid, then the evidence can be used even if the warrant isn't valid. I think and I hope that the court is going to extend that rule and say that any time, it would really say 2 things. It would say any time a police officer is acting in good faith, that the exclusionary rule will not apply. And secondly, that if he is not acting in good faith, if it can be shown that he has indeed violated the amendment deliberately or should have known he was violating the amendment, then the exclusionary rule should apply.
Dr. Zimmerman, how do you react to the comments that are made often? And Professor Schuster brought to my attention is that if you're not doing anything illegally or if you're not a criminal, you don't have anything to worry about, and you don't have to worry about these kind of protections. I know you weren't saying that, but it brought it to my mind that some people say that. No, definitely, I wasn't suggesting you did. And then you can respond too. But how do you answer
Well, I think
those
there are a couple of things that have to be said about that. One, of course, you have other kinds of protections. The difficulty, of course, is those protections are not very good. In terms of civil suits, policemen are basically judgment-proof. They don't have any money. We don't pay our policemen that well that you could sue them for very much. To the extent that they have, in some way, violated their jurisdiction's policy, the jurisdiction isn't going to be liable. The civil suit process hasn't worked very well. It's of course available, and the fact that those suits don't occur very often, and as they do occur, aren't very successful, suggests why the exclusionary rule is an appropriate mechanism. Secondly, the the exclusionary rule isn't really designed insofar as it's a deterrent question, and I'm not arguing really that it is a deterrent question, but insofar as it has something to do with deterrence. It doesn't deal with what happens in the context of the innocent person whose house gets searched illegally. The idea behind it is a kind of institutional deterrence. That is, that it says to the criminal justice establishment, these are the kinds of things you aren't supposed to do. And what it has said to them is that when you do them, there are some consequences to that. I think we can argue that the exclusionary rule isn't a perfect deterrent. Nobody's going to argue that it is. Illegal searches are going to occur. On the other hand, I think we can clearly show that the application of the exclusionary rule to the states changed police behavior. That police have said it changed their behavior. They have argued that they had to do things very differently. They had to train their people differently. They had to conduct searches differently. What that suggests was, since the exclusionary rule didn't change the law of search and seizure, didn't change anything in terms of making it illegal, what it did was to bring to the police's attention that they were doing things illegal. They were violating the Constitution, and they had to do something about that. I would suggest if you take away the exclusionary rule, take away that direct cost, if you will, of unconstitutional searches, you step right back to the situation before Matt versus Ohio, where you had, and perhaps it states it too broadly, but you had basically an honor code, which says you shouldn't do these things, but if you do, that's the way it goes. I don't think that's a very wise position to take. The exclusionary rule has some costs, but they are the costs of the Fourth Amendment. They're the cost of having some fairly complicated rules about what kinds of things police can do. But they're the cost basically of having a society that says privacy is important. They are part of a variety of rules which make convictions relatively difficult to secure. And I think that's appropriate.
Dr. Schuster, I want you to have the opportunity to talk about and add to this, too, what you were saying.
Well, let me say this. With respect to the matter of civil suits as a deterrent, a civil suit against the policeman is not going to be very useful because, as Neil said, the policeman is judgment-proof. The civil suit, however, against the jurisdiction, if jurisdictions would allow, or if the courts would mandate, if they could, that in cases of violations of the Fourth Amendment, that there could be a civil suit against the jurisdiction for which the police officer works, I think you'd have a very powerful deterrent in that kind of situation. The city of Spokane, for example, certainly is moving heaven and earth to do something about sexual harassment which allegedly took place in the police department. The reason they are doing so, hopefully they're motivated by something other than things having to do simply with money, but they're also motivated by the fact that it cost them a great deal of money because the police made this mistake. There's no reason why people who could not bring civil suits against Spokane or Idaho or any other jurisdiction if the officers who work for that entity have violated the Fourth Amendment. The advantage of that kind of deterrent would be that kind of deterrent would be available to both the person whose house is ransacked and something is found, that is the putative criminal, the person against whom evidence is in fact found, and the individual against whom there is no evidence or no evidence is found, who now is left effectively without a deterrent. Now, I agree with Neil completely, that we don't want to go back to pre-MAP, and I think the MAP decision had the effect, as Neil said, of putting police on notice in the United States that their conduct was not beyond the pale. But there's this problem with that. The idea of the exclusionary rule sees law enforcement as an essentially monolithic kind of enterprise, where police suffer equally as do other people suffer if evidence is not introduced into court and if a conviction is lost. Now, to an extent that is true, but only to an extent. For example, if the Spokane Police Department violates the Fourth Amendment and a case is lost, who suffers directly and immediately? Well, of course, the public suffers, you can argue. But in terms of the law enforcement establishment, who suffers is the prosecutor. It's the prosecutor who is going to keep or lose his job based on his rate of conviction. He suffers. Now, does the prosecutor have any direct control over the Spokane police? No, the prosecutor is an elected county official. The police chief, who is an appointed official of the city, controls the police. There is some interaction, of course, but there's not the direct monolithic control that the exclusionary rule assumes, Mr. President.
I would love to have a lot more time to go into, since Mount versus Ohio, the qualifications of the court. I know our own case in the Northwest, Washington State University, the Chrisman case, where talk about the elbow-to-elbow doctrine, they went into a room without a search warrant and all of that. Time, I just don't think is going to permit us to do that. I would like to help the viewers by giving you the opportunity to give us some specific examples. Let us suppose we're sitting in a room with some attorneys and someone's being advised. Give us 2 or 3 examples of where the police would err and it would be thrown out, and give us examples of what they could do and it would be admissible evidence.
Well, for me at least, Neil, perhaps, do you want to hand
No,
out?
go right ahead.
For me at least, the best thing to do would be to take an actual example.
Okay.
Take the case of not of United States versus Leon, but there is a case, a Massachusetts case, a follow-up on Leon, the name of which I can't.
Shepherd.
Shepherd versus
Massachusetts versus
right.
Shepherd.
Thank you, Massachusetts versus Shepherd. In that case, the police went to a magistrate having probable cause to search a particular place. They went to a magistrate and they got a warrant. But they had the wrong form. And the form also, it was a form for searching for controlled substances, which is not what they were interested in. So they went to the magistrate. They told the magistrate, we got the wrong form here. We've tried to fix it up so that the things, the Fourth Amendment requires that that the thing to be searched for be specifically described. And they were not interested in controlled substances. So they said to the magistrate, we've tried to fix it up. He said, don't worry about it. I'll fix it up. But he didn't. He left in some of those things. So they searched the petitioner's residence, found some material. It was sought to be introduced against him at trial. The trial court wouldn't let it be introduced on the grounds that the warrant was invalid, which it was technically invalid. It violated the specificity provision. The Supreme Court, following on the rule of United States versus Leon, the good faith exception, and I think quite sensibly, the Supreme Court said, look, this was a technical error on the part of the magistrate. Police are not to be put in the position of second-guessing a judge as to what is legal and what is not. They went in good faith to him, having probable cause. The fact that he didn't do what he was supposed to do and fix up this warrant should not prevent the evidence from being introduced. I think they were entirely correct in that particular case.
Let's do a reverse of that. Let's suppose that you have a very proper form, the search warrant, and you specify the persons and things to be searched or seized. And you get to the home, and as you're going through the premises and in the hidden drawer and so forth, you find items, but it's totally opposite to what you were there for, and you do seize those, and you make the arrest and so forth. Maybe you would react to that,
Yeah.
Dr.
You really don't have a problem in that case. That is, if you have the right to be where you are and the right to be searching for what you're searching for, and you find something else, which is evidence of a crime or contraband, whatever, that's okay. The difficulty would arise, say you had a search warrant that said we have someone who has stolen microwave ovens. I guess is a case we had here in Spokane. And we have reason to believe, we have an informant, or we've had someone seen him take these items into his house. So we get a search warrant for microwave ovens, and we go in and search. Well, so long as we are doing things appropriate to find microwave ovens and we find something else, we're okay. If we start going through his desk drawers, then the court is going to say, you're not going to find a microwave oven in his desk drawer. That was not a search for microwave ovens. You've gone beyond.
So you have to you look at where it's reasonable for that search.
Now, if I had a search warrant for cocaine, well, I could find cocaine in very small places. If I go into his house and search for cocaine, I'm assuming the search is okay, and I find stolen microwave ovens, and I have reason to believe they're stolen. That is, he's got, 10 or 12 of them, and they've got shipping labels that say they were supposed to go to someone else. I could perhaps seize those. That would not be a problem. So long as my search was confined to the things I was authorized to search for, I'm okay. If I simply happen to be in his house, say I'm a police officer, and he invites me into his house. I'm talking to him about a barking dog or something, and I see something there. He's got an illegal weapon, a sawed-off shotgun or something, in plain view. I'm okay. That's not an illegal search. I have a right to be where I am. He's invited me in. I have seen something. That's not an illegal search.
Also, if you have a search warrant and you're going in to search certain things, and maybe it's going to be hidden, but as you go through the living room, on the table is cocaine, whatever. And what you're talking about, the open sight doctrine.
Well, what
plain
you're
view
talking about is the
doctrine.
plain view doctrine,
Yes.
and that's what was at issue in Washington versus Chrisman, the case
Yes.
that you referred to earlier. The holding in Washington versus Chrisman, which, as you know, had to do with a student who was a police officer, accompanied him to his room and saw in his room contraband of some kind. And the holding in the case was the seizure of that contraband was entirely justified because the police officer had a right to be where he was.
Even though there wasn't a search
looking
warrant.
into. He didn't have a warrant.
Right.
He was just with him, and he was lawfully there. And that's the circumstance that Neil is talking about. There are all kinds of exceptions where police officers can search without a warrant. Normally, they must have probable cause. One of the most important exceptions is search of the person incident to a lawful arrest. And with respect to, that is to say, if a police officer comes and should come and arrest you right now on camera, he could search you and your body. You see, he couldn't search the things around you without probable cause to believe that you might be reaching for something or could reach for something. But he could search you without any necessity for probable cause. The fact of the arrest authorizes him to search you.
Also, isn't it correct that if you are in your automobile and you're not in your home, that and the police have cause to stop that automobile if it's it's mobile and moving? There are so many things they can do now without search warrant. They don't need a search warrant. Would you give us a little bit of the evolution of? They used to be very specific. You could search the passenger area, but not the glove compartments. Where they made significant
Opened
changes.
that very widely.
The original rule rested on the mobility of the automobile, that an automobile can move out of the jurisdiction very quickly, and since it can move out of the jurisdiction very quickly, you don't want the police to have to go get a warrant. Probable cause to search the automobile was necessary. This is in the Carroll case, which came out of the days of Prohibition. They were searching a car for moonshine. And for a long time, the rules were restricted, as you say. In recent years, in Belton versus New York, about 5 years ago, I think, the Supreme Court said, with respect to search incident to a lawful arrest, that said when you are talking about an automobile, the passenger compartment of the automobile is presumptively an area into which the individual could reach
But not the luggage.
for a weapon. The luggage compartment, no. Now, in United States versus Ross, decided a year or two after New York versus Belton, the court extended this and said that where there is probable cause to search any part of the automobile, luggage, containers in the car can also be searched without a warrant.
I'm so sorry to interrupt. We just got started. I would like to continue this. You've both been so articulate and informative, and I want to, on behalf of our staff, thank you for being here, and we'll have to have you back at some future date to pursue this further. Ladies and gentlemen, we've had two guests from Eastern Washington University that are political scientists, Dr. Joseph Schuster and Dr. Neil Zimmerman. Dr. Zimmerman's also Dean of the School of Public Affairs. We hope you've enjoyed this important discussion, and please be with us again next week. Until then, have a good week. I am Tony Stewart.
The North Idaho College Public Forum can be seen at this same time each week over this station. This production was videotaped earlier by a North Idaho College student crew for viewing at this more appropriate time.